entrepreneurs Justice, Original Jurisdiction, Case Management Conference in AGN OJ number 1 of 2021 between Ellis Richards, Medical Benefits Board, Spencer Thomas, and the State of Trinidad and Tobago. This morning's three-member panel are Mr. Justice Saunders, President and the Presiding Judge.
Good morning, everyone.
Good morning.
Mr. Justice Witt.
Good morning and good afternoon, Council.
Good morning.
And Mr. Justice Anderson.
Good morning, Council.
May we have the appearances, please? Thank you.
Thank you, Mr. President, Your Honours. I appear with Dr. Kenny Anthony, and we lead a team from the UK and from the Caribbean, consisting of Mr. Robert Strang, Mr. Gregory Pantin of Hammersmith, and Raphael Ajodia, and we are instructed by Mr. Miguel Vasquez. Your Honour, can I mention that we would like to join to our team Professor Matthew Happold of my chambers and the University of Luxembourg, and I would ask for his recognition in due course. That is my team representing the claimants today.
Yes, thank you, Mr. Davenport.
Your Honour, should it please you, Mrs. Deborah Peake leads me Tamara Tulsi for the Republic of Trinidad and Tobago, the respondent. We are instructed by Mr. Brent James and Ms. Carissa Singh of the Chief State Solicitor's Department.
Thank you very much. Okay, this morning's hearing, I don't believe would be very long. First, I'd like to hear from Trinidad and Tobago. Do you have any objection to the grant of special leave?
Morning, Your Honours. Yes, we do. We have instructions to oppose the application for special leave, and we will be respectfully asking the court to give directions for the filing of an affidavit or affidavits in opposition to the application, and we would ask for a reasonable opportunity to do so. We're respectfully asking to be given until the 5th of November to put in that evidence. Even though we were served with these proceedings, Your Honours, in July, we never got the complete copies of the annexures to the originating application until August. And you will have seen, if you've looked at the papers, that this involves events covering some 12 years, not only in Trinidad and Tobago, but elsewhere in the Caribbean, and in particular in Antigua and Grenada. So we would need some time to complete the taking of instructions and to put what we have on affidavit. It will be our respectful submission ultimately that the bailout of GORT in relation to companies in the CLF group falls out with the operation of the treaty, and therefore for those and other reasons leave ought to be refused. So that would be our respectful position today.
And you say you would like until November to...
The 5th of November, which is a little more than a month. Because while we have made some headway in taking instructions, you will appreciate, because it covers such a long period, it takes us some time to get the factual matrix together and to put it all together. Ultimately, we will contend that the allegations contained in the application are incomplete and or erroneous, and it's important for the court to have a full picture before it determines the application for special leave.
Okay. Mr. Davenport, do you have a view on this?
I do, Your Honour. Can I just say that although all of the other advocates here, particularly from the Caribbean, have had experience of appearing in front of this august tribunal, Mr. Strang and I and Professor Matthew Happold do not have that. We would just like to register our pleasure at this privilege of participation, and hope that we maintain the best traditions of advocacy that this tribunal expects from the best advocates and attorneys around the region. So we wanted to mark it by starting that way. Can I, just dealing with the substance of the procedural matters, say that it's right, and you've probably picked up on the fact that there have been a number of communications going back something like 2.5 years, intimating what this well-known matter consists of. So to bear this in mind for the purposes of striking a timetable going forward. And that includes a pre-action protocol letter 2.5 years ago in April of 2019, setting out largely the same submissions. And secondly, the applicant filing in reply 6 or so weeks ago in July. All of the annexures were e-filed and I think found their way to the respondents by the 10th of August. So they've had really quite a long time. We then gave them a prompt on the 28th of September and said, would you mind telling us how you'd like to proceed? And we made some sensible suggestions as to how to do that, including the management of joinder of more claimants to be heard in due course. And we didn't hear word on any of those occasions whatsoever. It was only yesterday late afternoon when we actually finally got told that there would be resistance on the facts and the law, which doesn't say very much. We then pressed them yesterday afternoon to expand upon that, and we've had no such expansion. So all we've heard this morning is all that we know about the reasons why the state would want to resist it. And I think we therefore want to cooperate and have an effective and time-effective procedural handling of the case management of this matter, Your Honour, but we're slightly in the dark, as I think you'll understand, as to what it is, the scope of the matters that are going to be taken. So can I, in any event, suggest that what would be cooperative and sensible and time effective and would help this court is if that we could be told by correspondence prior, as it were, to any date that you set, what the matters are going to canvass, because then it will allow us to prepare material accordingly. With that in mind, I mean, another month is quite a long period of time. If they have formed the view that they're going to resist, and bearing in mind that the only test is going to be arguability, then we're somewhat taken aback that they should need such a long period of time. So I think my first position would be it's obviously important that this is a proper bilateral matter and we get to hear precisely what it is that the respondent wishes to say. Nonetheless, they should be encouraged to get on with it as soon as possible. So could I ask you to just look again at whether or not you're going to indulge them with a further 1 month? We would ask for at least the same amount of time that you give them. Now, obviously, if it's less than a month, if you said 2 weeks, then we could be looking at a lesser period of time. The only thing is that they've had 2.5 years in order to see that this is coming, and certainly 6 or 7 weeks. We simply don't know whether or not they're going to be taking a few points that can be corrected by way of the introduction of facts in due course. Or whether or not it's going to take rather a longer period of time. So I hope you understand why we would say that. We want to help as crisply as we possibly can, but I think the reality is that we will probably need a month anyway, and possibly longer. So being realistic, so that we don't have to come back and ask for extensions of time. So that would be my my first suggestion of how to go forward. My second suggestion would be, it will be critical, I think, to impose sequential submissions, because that will give us a best chance of understanding what the criticisms are. So either one of two ways, either, and I think this would be the better way, that they, after the exchange of factual evidence, which is going to be sequential, that then the respondent puts in its submissions first as to why they are suggesting that there shouldn't be special leave, and then we will respond. And that will be a two-stage process, and leaving us to respond to them. If you were to take a different view and there was some mutuality, we are going to have a reply that comes at the end, so that as well we have the last word. That would fit normal practice and would be the best way of progressing. So at the moment, those are the submissions that I'd like to make in respect of what my learned friends have suggested about how to progress this matter. Yes,
thank you. I would only observe that if you had sent a pre-action protocol in 2019, it can't be that there's a great degree of urgency such that it may be necessary to deprive the respondents of the time that they wish to take?
I've got a lot that I could say, Your Honour, but I respectfully accept the logic of what you're saying. I don't think we want to fall out over a week or two either way, because we want to get this matter in proper shape so it can be properly deliberated. I mean, it's a matter of vast public importance, and we have to have the right arguments before this court.
Yes, I just wanted to clarify though, in relation to both sides, the approach towards the submissions on the objection. I take it that the respondents would go first. You would respond. Is there a view that there should be another round, that the respondent should then have a crack at the responses that you make and then you respond? Or should we simply have the respondent's objections and your response to those objections? Do you have a view?
I think the latter. I think that's a better way forward.
Yeah. Okay. Ms. Peake, is there anything that you wish to say further?
Safe to say that it is usual where you have 2 rounds of submissions and the party who goes first has an opportunity to respond. Now, the court can either make an order to that effect, or you may reserve the right to hear oral submissions, because it may be that the court doesn't have the benefit of what we might have to see on my learned friend's submissions for the applicant. So the court would be deprived of the benefit of our views on what they've had to see in response to ours.
Yeah, well, in any event, it would have been our view that we would have oral submissions on the written material in any event. So you said you wanted the court to allow you until when?
The 5th of November, which is a Friday.
Yes. Let's look at the calendar. And Mr. Davenport, that would mean that you would wish to not have to respond before a month's time. Is that the case?
Yes, Your Honour, that would be the case.
Okay. We had hoped that we would have heard, in the event that there was going to be an objection to the application for special leave being granted, we would have heard this before the end of the year. Give us a few minutes, remain on the line. The bench is going to have a short confab, and we'll come back and let you know our views on the timetable.
Thank you, Your Honour.
Much obliged.
Okay, I think we are back. We are minded to allow Trinidad and Tobago, as they have requested, until the 5th of November to present their written submissions on their objection to the grant of special leave. We would give the applicants until the 3rd of December to make their written response to the submissions of Trinidad and Tobago. And we would give Trinidad and Tobago until the 17th of December to respond, to reply to those written submissions of the applicants. We are minded to have an oral hearing on the application for special leave and the objection made to it on the 18th of January.
Thank you. Might I respond first, Your Honour?
Yes.
We're very grateful for you taking the time to do that and take note of it. It may be that there was an understanding or maybe it wasn't clear in what Mrs. Peake was trying to ask. But I think you have seen the right answer to this. Mrs. Peake, I think, was trying to suggest, certainly the letter that we received yesterday, was suggesting that they have factual input by the 5th of November and then factual responses together, and then thereafter submissions, as it were, as to law, as to the reasons why there shouldn't be special leave granted, which would be round 2, together with responses by the applicants. But it strikes me that what you've seen through in your orders is that they obviously are interrelated, and they obviously should be coming back with one document, one letter, or one position, one skeleton argument, which says the facts which they seek to rely upon. And I'll just outline the facts in a moment. And secondly, the submissions of law as to why the case is not arguable, particularly if they've already apparently reached the view that they...
Counsel, I'm sorry, but do we need to go into this? I mean, you seem as if you're arguing the case of Mrs. Peake.
No.
I thought the president had outlined a schedule to prosecute this matter, ending with a hearing on the 18th of January. I think he's asking whether there's any objection to that schedule.
No, not at all. Thank you, Your Honour. That's a very helpful intervention. I merely wanted to say that I think that we'd anticipated that there were going to be 2 rounds, but I just wanted to say with approval, with respectful approval, that I think that is a sensible idea, as long as the facts are constrained to what is set out by Rule 10.4 sub 2, which is those which are before you, including, for example, the interests of justice, and also the fact that I'm suggesting that it's a good idea that their submissions should be coming at the same time as the factual input. So, Your Honour, Mr. Justice Anderson, I'm grateful for the intervention. Thank you for steering me back onto the path. But that is what I meant to bring to the tribunal. Okay.
Wonderful. Thank you.
Are the dates fine with you? Are you available? Is your team, well, I don't know, you've only had notice now, but I'm going to take it that your team is going to be ready as the other side on the 18th of January for the oral submissions.
Your Honours, would you hear me on the announcement that the court has made? My learned friend was right when he sought to intervene, and I'm grateful to him because he correctly understood that our position was we wanted an opportunity to put in factual evidence. My learned friend said he wanted an opportunity to respond, and thereafter there would be submissions. It would be quite strange in our respectful submission if we were to file submissions on an application before the evidence is closed. My learned friend says he wants to file evidence in opposition. Now, if he doesn't want to do that, then of course we will be happy to file our submissions, even though it will put us under tremendous pressure by the 5th of November. But it can't be in our respectful submission that we file our evidence, point out what are no doubt deficiencies and defects in their evidence, file our submissions, and my learned friends have an opportunity to come back within a month and correct or attempt to correct those deficiencies and file submissions, really nullifying what we have said. So in our respectful submission, there is good reason to have two separate rounds. And even though I appreciate the court wants to deal with this matter with some dispatch, we have to look at it in the context of, first of all, Learned Friend says they sent a pre-action protocol letter, which we have not seen. It has not been annexed to any of the proceedings since April 2019. They took 2.5 years before they formulated their claim to come to court. We are weeks after, and we need to have a fair opportunity to respond. The court will appreciate we are dealing with a potential claim involving millions, I dare say hundreds of millions of dollars. We don't know what the extent of the claim is because we haven't been told, and there's a tremendous possible exposure on the part of the state of Trinidad and Tobago. In that context, we don't think it is at all unreasonable to say, let the evidence be closed before the court receives submissions on the application. If my learned friend says they will forego filing any evidence in opposition, well, then we will comply with the directions and file our submissions at the same time. But it would be quite unjust in our respectful submission to ask us to commit ourselves to our submissions. My learned friend sees where we are coming from and they have an opportunity to do a patch up in their evidence in opposition. So we would respectfully invite the court to consider what we have said in giving its directions. And we say, while we appreciate a hearing in January, having regard to the way the case has progressed and the vintage of the matters complained of, I don't think my learned friends can reasonably complain if we have a hearing date after January.
Okay, let's take a step back here, okay? This is an application for special leave. This is not the hearing of the claim that is made. This is to determine whether the claim should in fact be heard by the court. So that we need to be careful that we don't dress it up as if it is the claim itself. We really just need to determine whether or not this leave should be granted to the applicants. If there are factual differences, if there are differences on the facts, then why can't those differences be pointed out? And after we have seen all the various submissions, the court will have to make a determination as to whether, in order to simply assess whether leave should be granted, it is necessary to have some hearing where persons can go on oath and be cross-examined, or whether that is unnecessary. So, but Justice Witt, you wished to say something?
Well, I was about to say that evidence is really not for this pre-procedure. Evidence comes in once we have given special leave to bring the case, and then evidence, normally speaking, would be essential. But this is about whether we should give special leave to, as the President said, to have the case brought before us. So that is more a point of legal argument than anything else. That I can't see now that there will be points of evidence that may be relevant. I doubt it, but we'll see. But of course, the application for special leave procedure is not about evidence. As you will see in the rules, when we talk about evidence, that is always about the case as it is brought after special leave has been given. So, I think I totally agree with the President that this is not yet relevant. We need to get the argument why not special leave, why special leave should not be given. That is the point.
And I think Senior Counsel Davenport, Queen's Counsel, my pardon, made the reference to arguability. I mean, that's a standard, of course, on which is decided whether the case goes forward to being heard on the merits. So I don't know, Senior Counsel Peake, whether that will influence you or your client in relation to the question of opposition to the grant of special leave. But one way or the other, remember that the standard is simply that of arguability, whether it is arguable that the application ought to be granted or not.
Your Honor, we fully appreciate that, but if it is that the factual premise on which the application is based is simply wrong, then I think the court should appreciate what the factual matrix is in determining arguability. Now, the court has already said that it would give the parties an opportunity to put evidence in, so I think we've gone past that. I think the only question is whether the submission should be filed before the evidence is closed, and that's the simple point that I'm making. We've asked for an opportunity to put in evidence. The court has agreed. My learned friend says he wants an opportunity to respond. The court has agreed. And therefore, the only difference between us, it appears, is whether we should commit ourselves to submitting that the application is unarguable until the evidence is closed. And that is really the only issue. And we are not at all confusing the application for special leave with a substantive claim if it is allowed to go forward. But the fact that the court is empowered by the rules to give directions means that there's no limit to the kind of directions the court can give. And if in the interest of justice it says the party should have an opportunity to put evidence before the court, then that is what we will do. And so therefore the only question is whether we should put in our submissions at the same time as we put in the affidavit in opposition, or whether that should not be done after the evidence is closed.
But you are speaking about the affidavit in opposition, but that is something the original jurisdiction rules do not know. That is in the appellate jurisdiction. That's where you file an affidavit in opposition. That's not something known in the original jurisdiction rules. So what we have said is that you can file written submissions, or at least, yes, you start with filing the written submissions. If you want to add some evidence, I suppose that you would be okay. And there will be a reaction to that, and then you have a reply. And that is what we have to do with. And then we will hear you and the other side in January, and we will decide whether special leave will be given. There will be no cross-examinations and all that stuff. I don't think that is at all the idea of this particular procedure. So for those things go to the procedure itself. So it might be that the facts are relevant to this particular application. We'll see what you bring us on the 5th of November and what the other side has to say about it.
So, Ms. Peake, for the avoidance of doubt, what we want is on the 5th by the 5th of November, or not before the 5th of November, you provide us with your submission as to why special leave ought not to be granted. If those submissions involve issues of fact which you think render the special leave application not being one that is arguable and not to be dismissed, then you mention those in your submission, and the other side will respond. You will have a right to reply, and on the 18th of January, we will have an oral hearing on the matter. So that is the course that we propose should be followed. Do you have a difficulty with the dates mentioned?
No, the 18th of January is a convenient date.
Yeah. Okay. All right, and I take it that is similarly the case, Mr. Davenport.
That is, Your Honour, exactly so. This is not the place for jousting, and so I won't. But I encourage Ms. Peake to stop doing it either, because when she says we will have an opportunity to patch up the position,
Mr. Davenport.
Yes.
Mr. Davenport.
We don't know what her position even is.
Let's not go there. Let's not go there.
Okay. Well, you can see where I was going anyway. Well, I'm very grateful.
Okay.
And I think you expressed what I was going to say in any event. So I'm very grateful, Your Honour.
Okay. So I think we're done. Just to repeat, and you will get a copy of the written order. The state of Trinidad and Tobago would file written submissions on or before the 5th of November. The appellants will file a response to those written submissions on the 3rd of December, on or before the 3rd of December. Trinidad and Tobago would have until the 17th of December to file its reply, and there would be an oral hearing on the 18th of January. Now, Speak, how long do you think you would be? I don't know, this might be an invidious question because you haven't seen all the documents, the submissions and stuff, but how long do you think you are likely to be on the 18th of January?
I think you have anticipated the difficulty that I'm faced with, but I would envisage for budgeting purposes an hour and a half.
About 90 minutes. Okay. Mr. Davenport, we wouldn't expect you to be longer than that.
I won't be longer than that. And of course, the court might decide that it doesn't need to trouble me on any of the issues or some of the issues. That will really lie within the court to direct me, but I will not be longer than that in any event.
Okay. So we make provision for 90, 90, and 30. That's what? 180 plus 30, 210, that's 60 minutes in an hour. That you can do that in a day. So we would include that in the order, a maximum of 90 minutes each, and a maximum of 30 minutes rebuttal. The written submissions, we have been, as a court, trying to discourage voluminous, prolix submissions being sent to the court. This is a big matter. This is an important matter. When we had our confab, the judge a little while ago, the judges didn't discuss this issue. But I would simply urge that the submissions be succinct and not prolix. But we are not in a position now, we are not minded now to impose a page, a length of page requirement. But I would just urge that the submissions be succinct. Is there anything else that can be usefully discussed?
Not from our side. We have no issues that are fresh.
President, I was wondering, it was not clear to me, who will speak first on the 18th?
Well, I think the moving party, in a sense, is Trinidad and Tobago, but they should set out their objections. But maybe we could hear a little bit from Ms. Peake and Mr. Davenport on that.
We are entirely in the court's hands. Whatever the court's preference is, we will comply with that.
It's a difficult one. The normal way would be that we go first. We're seeking special leave, in which case we go first. There's a response, and then there is a short reply by us, very short reply if necessary. Of course, in a situation which is more aired than that, the court can reverse that and simply say we want to hear from the respondent first, and then you might not need to hear much, if at all, from me thereafter.
Okay, I tell you what, we'll defer that question for a bit, and we would let you know.
We're very grateful.
Yeah. All right, so that's it, I think. Thank you very much, Councillor. We'll see you on the 18th, but before that, we look forward to receiving your written submissions. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.